Today in this discussion that will be going on, we will be covering a few topics related to the various laws, the system of justice, the system of courts of our country. Starting from the drafting of the Constitution of India till 2014, there was a particular set of events that have taken place, many of which, or rather mostly, were to some extent anti-people in nature. Some were pro-people in nature. There are various debates on them, and a wide range of government policies have come over during that period of time. There was the Congress government, the policies of the Janata coalition, the pre-Modi BJP government, and so on. But considering 2014 until date, what we should start with is that we, the people of India, want to know, or rather the nation wants to know, that how much the entire law landscape of our country has changed. What type of justice do we expect during this period of time? And for this we have Saptarshi Banerjee, practicing advocate of Calcutta High Court. So the first question that I will be posing to Saptarshi is that how much has the law landscape changed since the advent of the Modi government in 2015?
To start with this, I think the biggest change as such has happened with the perspective. If you actually look at it, even jurisprudentially, certain changes have come across as a shock to lawyers, low and mighty everyone. Sometimes a feeling has, unfortunately I would say, a feeling seems to have come into being, and this is not just with the civil society, but lawyers practicing in the different high courts and the Supreme Courts, that somewhere down the line the judiciary is taking a very soft stand on the government. Now, of course, it's a matter of classical debate as to how much the judiciary should intervene in matters of public policy, executive, which is otherwise a domain of the executive, political executive, so to speak. But then again, the Supreme Court, if you look at the constitutional framework, Supreme Court and the High Courts were put in place as a check over this political executive. Whenever they overreach their powers, whenever they act in violation or in breach of the Constitution or the constitutional framework, the Supreme Courts and the High Courts have come out and have basically cracked the whip. But for some time now, there is a growing sense that the judiciary is not responding the way the lawyers and the civil society expect it to be. Apart from this, obviously, if you see the kind of laws that have been brought in by the Modi government, be it Modi 1.0 or the Modi 2.0, it seems that it is going against the old order. Now see, there is no reason to believe that the old order is absolutely sacrosanct and nothing can be changed. Of course, the old order needs to be tested and it needs to change whenever necessary. But that doesn't also mean that while changing that old order, you completely demolish whatever good was there. For example, the citizenship laws. We have never had our citizenship divided or dissected on the lines of religion. But this is for the first time that kind of an issue has cropped up in public discourse. Now we will have to now wait and watch, as many Supreme Court advocates, including Prashant Bhushan, has pointed it out earlier, that who is a senior advocate practicing in the Supreme Court. I think he pointed it out once some time back, that it is ultimately the people. If the people really rise up to the occasion, the political class will be fearful, and even the judiciary will to an extent start responding. but to an extent there is that sense of complacency in the people. I don't know what will happen after this COVID crisis. I think that is yet to unravel itself. But in the coming days, in the coming periods, we might know better.
So as we proceed further, business is the main talk of the town. So we should be dealing with some questions related to the business area. Now, for the last couple of years, we find a wide range of difficulties which the national banks are facing. The non-performing asset and other such terms are brewing in the air. And amidst this, we also find a particular type of a code which in 2016 the central government has passed, the Insolvency and Bankruptcy Code. There are various questions which are arising related to this code on the definition and the distinction of the different types of operators and all that. So, what is your view on the Supreme Court's judgment on the constitutional validity of this Insolvency and Bankruptcy Code 2016? And I would also add that if you can lucidly explain what is it all about.
In new policy, there are some questions that have arisen. One question is, see, there were something which we call the DR, the Debt Recovery Tribunal, which was already existing. Now, jurisprudentially speaking, if you are a lawyer and if you have a grasp of these commercial legal technicalities, you will understand that it is different. But from a macro policy perspective, you will understand that there is already a redressal mechanism available. Now, to actually expedite that through this Insolvency and Bankruptcy Code, even though jurisprudentially again speaking and technically speaking, it is not the same procedure. Okay, but then again, from different statements from the government, we have come to learn that that is the basic idea, so that banks do not suffer in the hands of NPAs. Now, I do not understand where this policy confusion will go.
So, now coming to some tougher issues, some tougher questions. The question is not tough, but the issue is tough to speak even, because it's about Jammu and Kashmir and it's all about our neighboring states. We say neighboring because though they are our sister states, but we usually neglect them because that is the northeast part of our country. So the first question will obviously come related to the Armed Forces Special Powers Act, AFSPA, which has been enacted in Jammu and Kashmir for a long period of time in various states of the northeast and in the mainstream states of our country. And also the second question will be related to two articles, Article 370 related to special powers of Jammu and Kashmir and Article 371, which many of us are usually not aware of, that it also gives special powers to various other states of our country when they actually joined the Union of India. So the question is that, do you consider AFSPA as a fascist tool of subjugation? And what is your view on Article 370 and 371 and their present fate?
I think no person in his right mind would ever stand up to defend something as brutal and as abhorrent as the AFSPA. And very honestly, if you look at it, even our former Prime Minister, that is Manmohan Singh himself, had commented that AFSPA must go. This has been a great debate of political crisis, I think, within the Union of India, where different, including the political executive, which was the proponent of AFSPA in certain regions initially, have later realized that it must go. But then again, there is a sentiment of the armed forces who work in such insurgency-ridden areas, so to speak, who oppose this vehemently. Now, if we go on to elaborate further in this will get completely deviated into a different issue as to whether the army should have any say on it or not, and if army has a say on it, whether army would do this to basically go on doing a lot of things which the army has been otherwise accused of, to continue doing such things, including the Pune and Poshpara incident, to keep on doing this with impunity. Now, these things have been largely debated, and I think, to my mind, however, there is no doubt that AFSPA must go. 370 and 371C, it's a simple thing. As a country, we made a promise. Now, whether those promises were right or wrong is our internal dispute. Okay, then we have to settle those disputes internally. But as far as the way the central government really proceeded with the abolition of that law, I think many are of the belief, and many apprehend, that this will further alienate Kashmiris. And legally speaking, it's nothing new. We have been giving separate benefits to different parts of India, and which basically the federal structure permits us, the constitutional federal structure permits us to. People do not know that states like Karnataka has a state plan, but it is within their rights to have one. Similarly, Kashmir annexed with us under certain conditions. Now, yes, some very bad things had happened after that, and there were some cases. These are more to do with the politics of it, Sumit, and really little to do with the law. But unfortunately, the law is the first goat to be sacrificed in these cases. What happened, if you look at it, is it was a case where the central government used Kashmir for a lot of political, in fact the political party that is in the government today, used Kashmir as an electoral issue for long, and now it had to basically do what it did to satiate its political vote. But as far as how far it will help the democratic fiber of this country needs to be seen, because we have, at least I have not read of a situation where 3 former chief ministers of the state were put behind bars to implement a law. Shah Faisal, as far as I know, is still under detention and is still under house arrest. I do not know if the house arrest over Shah Faisal has been withdrawn. That is, PSA has been revoked.
So, in continuation with our previous discussions on Kashmir and its sister states, so when the Article 370 was abrogated, we found a specific situation where a large number of ministers, MLAs were being detained. So, in connection with this, I want to ask that what is your take on the Supreme Court's attitude towards the petition which was filed by the CPIM General Secretary Sitaram Yechuri regarding the detainment of the Jammu and Kashmir MLA Mohammad Yusuf Tarigami following the abrogation of Article 370 by the Parliament, and to add, even no justification was given to validate the detention which was imposed by the central government.
See, to be very honest, I think it was legally unnecessary. You have to understand that in law, when there is a detention, I can challenge that detention and the court will have to pronounce. This is the constitutional obligation of the court, that the court will have to pronounce whether such detention is right or wrong. Okay. What does it mean if somebody says that the court allows me to meet somebody? It's like if the detention is invalid, then the detention is invalid. If the detention is illegal, the detention is illegal. There is no reason for me to actually approach the court for the court to allow me. I must just ask the court to call that detention for what it is, and allow the person his rights, his constitutional rights protected under the Article 21 of the Constitution of India, but and also Article 19, in fact, free movement. But this was, I think, a very, very low point in our jurisprudence as well.
Starting from the later Vedic period, we know that reservation is a big issue, since casteism itself is a big issue. And right from the various movements that have sprouted up in our country under the leadership of Dr. Ambedkar, we find that the Supreme Court in due course after Indian independence has also exhibited various important positions, while restricting the reservation to 27% in various cases, to quite recently stating that reservation is not a fundamental right. So my question is that what is exactly the court's attitude towards reservation in course of all these years of independence in our country?
No, there is a small correction. The Supreme Court doesn't really say that the reservation is not a fundamental right. It says so in a context which needs greater detailing. So for clarification, the Supreme Court still hasn't said that. The Supreme Court cannot say, because the Supreme Court is a creature of the Constitution, and the Constitution vests protective positive discrimination as a right. It's a part of Chapter 3. It is a part protected as a fundamental right. So I don't think the Supreme Court has the brief to even say that reservation is constitutionally not valid. It is, however, a different social issue, and whenever this reservation issue comes up, I normally, if you see that there's a lot of opposition from the upper castes that I come from. I am from Indore here, so many people around my circles, my friends, my relatives, they have this very general understanding of reservation, and they complain about reservation. So to them, I just have a simple question, and in fact, I have heard some young left-leaning guns of the day also say the same. I think if you have a problem with reservation as to how the lower castes have been given certain benefits, but it's not really a benefit, it's really an opportunity to come and match with the rest. And if you really have a problem with that, then why don't you seek reservation instead of objecting to their reservation? Go seek reservation in manual scavenging jobs. The problem is the Brahmins never want to think on those lines, and it's not really the problem of the person who is born Brahmin, it's the social conditioning around that person. So we tend to see things and think of things from where we already are, and we tend to ignore as to how we reached there, the kind of inherent privileges that have helped us through. For example, if I do not take into consideration that we are talking at the time of lockdown, right? In a situation where virtual courts are the norm of the day. Now, I am somebody who has been educated in an English medium school. I have been somebody who has been educated in a better known law school in the country, and then I have joined practice on the original side under a very famous barrister practicing in the Calcutta High Court. Now, there are lawyers who literally struggle and who come from different backgrounds, from different villages, and somehow they have managed to create a niche for themselves practicing in the Calcutta High Court. Okay, so me and them, when we compete, there is an advantage that I have of about 20 years over them. and still they have managed to survive in that competition, and I think it's kudos to them. Okay, sometimes they do even better, and that also goes on to show that their hard work really has paid off. But at the same time, I must also understand that just because they are doing better, there's no reason for me to hate them and say that, see, they have gotten where they are through some channel, through some lobby. Maybe yes, some do, but these lobbies and these channels have only helped ease that gap, that advantage of 20 years gap which otherwise I anyway had, which I inherited for no good reason of it. I just happened to be born at a more privileged family. So it's the same thing with the reservation. If you are really so mindful of this, then you must also say that let there be a reservation in all sorts of jobs. You should demand that out of the 100 manual scavengers in the city of Calcutta, at least 20 should be Brahmins. You do not do that. It's actually a social year, and as far as the legal thing is concerned, I think the constitution is very clear about reservation. Yes, there is one issue, however. In the initial scheme of things, reservation was supposed to be a benefit which was given to the people of the country, that is the downtrodden and the oppressed, for 10 years. And after 10 years, we were supposed to have a relook at it. But then as things went on, if you visit rural parts of India, caste is still a big question. If a lower caste touches the well of an upper caste in certain parts of India, that person is murdered. So if we couldn't sort that out in 70 to 80 years, then how can we expect that the issues regarding reservation will be settled within 10 years? It is not possible. Once the social conditions change, the legal conditions will follow.
RTI is an important tool to us. Recently, by the help of RTI, it has come to everyone's knowledge that the RBI had exhibited favorism towards a wide range of famous defaulters of our country, be it Nirav Modi, be it Mehul Choksi and the entire gang. But what my exact question is that, do you think that the centre's decision to amend the RTI Act will eventually weaken it?
That seems to be the worry, that seems to be the attention. In fact, RTI is one of the best things that has happened to India. And I think RTI passing of the Right to Information Act is one of the brightest stars of the Indian Parliament. This is one occasion where everybody would admit that we kind of opened up to transparency. At least we tried to. Any attempt to dilute that, I think, should be seen with contempt, and there isn't any two ways about it.
So, what is your opinion on the Supreme Court's decision to uphold Aadhar? And I must add, along with this question, that even Justice Chandrachud even sent a note of dissent related to this issue.
See, that dissent, I think, is a must read in the Kutuswamy judgment. But if you see, every judge ultimately goes on to unanimously hold, if you read the judgment, every judge actually unanimously holds that right to privacy is a fundamental right protected under the Constitution of India. However, I think the majority judgment somewhere down the line fails to do the kind of justice that it deserves, because a lot of questions regarding breach of privacy in the Aadhar judgment, actually, that is the majority judgment, actually remains unanswered.
आधी रोटी खाएंगे पर मंदिर वहीं बनाएंगे. मंदिर तो बन गया है. So we also have a question related to this. Did the Supreme Court convert the Ayodhya Ram Mandir issue into a mere land dispute case in its historic verdict? And another question I want to add here is that as the relation of religious institutions and the context of land grab comes to the forefront, do you think that this is a judgment of compromise?
See, if you look at the interim initial orders of the Supreme Court in this matter, I think that is where the Supreme Court decided to deal it purely as a land dispute, as a title dispute, and not get embroiled into the entire political religious issue. And I think the Supreme Court did the right thing to that extent. But then once you start dealing in a title dispute, the title dispute is normally sorted at evidence. And I really hope that this judgment is someday revisited by the Supreme Court in the days to come, and hopefully that is sooner than later. Just like the Indian Jabalpur judgment of the Honorable Supreme Court of India, I believe this is a black spot. This judgment, I think makes a lot of mistakes, especially to start with. If two parties are rivals to a contention of land, if both are claiming title to that land, then you will have to find a positive assertion in evidence saying that this land belongs to somebody else, okay, or this land belongs to this one person. This judgment goes on to show that the evidence, and in fact this judgment concedes to that extent, that the evidence produced by both parties are insufficient to prove a positive case. But however, then it comes up with this weird argument that since one party's witness believes that this was Ram Janmabhoomi, and the other party's evidence also admits that their belief is that it is Ram Janmabhoomi, and then further proceeds to write the entire judgment on it. So it's basically on belief. So tomorrow I can say that you can come and say that this chamber is yours, and let's say person A is my witness in the court and says that no, this is Saptarshi Banerjee's chamber, and person B from your side comes and says no, this is Sumit's chamber. But then when a question is asked to my witness, what do you think Sumit and Sumit's people know about this chamber? So my witness says yes, Sumit and Sumit's people has always believed it is their chamber. That cannot be a ground of coming to a positive finding in a judgment, which unfortunately it does. So I think this judgment needs to be revisited.
So the Supreme Court has given a clean chit to the central government on the Rafale bill.
Not necessarily. Yes, the majority judgment does say that there is no need for an investigation as such as of now. But if you actually look closely at the judgment, and if you actually read Justice Migrant present, in fact, this is again an interesting turn of events where we take solace in the dissent more than we take solace in the majority judgment. So the dissent is very important, and in that dissent, Justice Migrant actually says that a fresh case, if registered, can be investigated. However, at that point of time, whatever materials were before the Supreme Court couldn't find anything to really go ahead with the kind of prayers that were involved in the petition. But yes, I think Justice Joseph's dissent is an important receipt in this regard.
No NRC, no CAA, no NPR.
The mantra of the day.
The mantra of the day, yeah. So, what is your view of the NRC? Specifically when the former Chief Justice of India, Ranjan Gogoi, had once on a public occasion in Assam endorsed its proceedings, even endorsed in Tripura.
See, I have honestly failed to understand the objective of the law. And why people are talking about the constitutional bodies and everything, and which needs to be talked about very honestly. A very important, significant, dispassionate exchange needs to happen on those lines. The constitutional bodies are finesse. I believe in that.
CA unconstitutional. What do you think?
To the extent that it for the first time
You are giving citizenship on the basis of religion.
see, possibly you can do that, but you will have to make a reasonable classification for that. I think the law will fail where the central government will possibly fail to show as to how it has been able to show the reasonable classification. On the basis of what has these countries been classified, and on the basis of what has these minorities, so-called minorities within these countries have been classified, and how does that go on to achieve the object of the law. That is really the constitutional test for the bodies of any law. Okay, so I don't think it really goes on to achieve those objectives, because at the end of the day you are saying that you want to give minorities in these countries, the oppressed minorities, a platform of refuge, but then there are other oppressed minorities in those countries, and at times you are relying on the domestic legal definitions of how these countries claim themselves, as in how these countries define themselves through their constitution, as in if Bangladesh mentions in its constitution that it's an Islamic republic, then you say that it's an Islamic country. You are relying on that. But if Pakistani domestic laws do not treat certain Muslim minorities like the Ahmadiyas as Muslim, you are saying no, that you are not going to rely on that domestically. So you are picking and choosing according to your convenience, and I think that should fail the test of reasonable classification.
So if we have a census, a practice of census for a long period of time, why is a new NPA? Why do we need an NPA if we already have a census?
I don't know, because I am not in the government, but yes, I see, if you look at it, they do include that doubtful citizen clause. I think that is just the basis, so that they want to create a basis initially so that they can further move on with this in NRC, CA, mumbo jumbo, and which is basically nothing but creates a lot of confusion and a lot of political unrest, and some political dispensations tend to enjoy vote bank polarizations due to such political unrest, and I think that is their objective.
Coming to issues of the lockdown era of our country. While the state high courts are up in arms against some unjust treatment towards the migrant workers, we find that the Supreme Court has accepted the centre's report that the migrant workers are well taken.
Yes, initially it is again a situation I think is laughable to an extent, because initially that was the understanding, and that was the understanding given to the Supreme Court by the law officers of the centre. However, later on the Supreme Court had to take action, and the Supreme Court actually pulled on the central government and started a proceeding on its own motion, even though initially it had rejected. So that goes on to show that the Supreme Court couldn't sit tight, and no judiciary in its right mind could have sat tight.
So, release the political prisoners. This is a very important slogan nowadays in the mainstream political arena. So the question is that what is your view on the pleas related to the release of Sudha Bhardwaj, Varvara Rao and other intellectuals, specifically even when Noam Chomsky is even preferring for their release?
I don't know, Sumit. I have never, I couldn't witness, unfortunately I couldn't witness the days of the emergency. But you are a well-read guy yourself. Do you think you have ever heard of a situation post-emergency where so many political prisoners were behind the bars? I think it's unprecedented. I think there were just two occasions in the history of independent India. One was the emergency and one is this. And so many people who are put behind bars simply because they are politically active and they have a critical tone towards the government and some of its actions. It's really unbelievable. It's not just limited to the case of Sudha Bhardwaj, Varvara Rao. It is also this recent case of Safura Zargar, I think that's her name, who's pregnant and who has been kept behind the bars simply because she decided to protest on the NRCCA issue. And this is unthinkable. This is unheard of. As to how, because our jurisprudence clearly states that the bail is the rule, detention is really the exception. However, in this case, and in most of these cases, the cops have failed to file the charge sheet in a timely manner. Just yesterday, I think the terror accused former superintendent of police of Kashmir, Davinder Singh, has got a bail on the same reasons that the charge sheet couldn't be filed in a timely fashion by the investigating authorities. But these things are not happening, and in fact it is very interesting to look at this Yelgar Parishad case of where especially Gautam Navlakha and Sudha Bhardwaj and all these people have been put behind bars. As soon as the Maharashtra elections happened and there was a different government, the central government actually took the entire proceeding under its own belt, which is unheard of, because normally this was a case initiated by the state of Maharashtra initially. Why would it have to suddenly be transferred to a different governmental dispensation simply because the government in the state went through a change? That, I think, reeks of conspiracy. With the greatest of respect to the powers that be, I think it's really condemnable. And
Counter-based murder of Hyderabad counterparts. Justice Chandrachud had publicly stated about the drawbacks of the present system of justice, its logics and everything. So what is your take on Chandrachud's views?
Against, another case of executive overreach. Even though there is a growing public sense that these trials, time-consuming trials, are actually self-defeating of the entire purpose of justice, but the answer to that is really how to expedite the process, but not to do away with the procedure, not to do away with the checks and balances. In this case, in the Hyderabad encounter case, we will never come to know, because those people will never be put on trial, and there will be no testimony in the court. And if you actually look at it with the other jurisprudences that we've always actually really kept dear to our hearts, every accused has a right to meet his or her accuser in a court of law, in front of public. Now these people, we do not know if they were the real guilty, and we will never know. Yes, to an extent there was that instant sense of justice, so a lot of celebration was in the air, a lot of people thought that justice has been done. But I do not know. What if another Davinder Singh comes out of that investigation tomorrow? What if we find out that there is another officer involved in these encounters or these investigations who was actually a corrupt official, who had a history of working working after being paid by the landlords and the feudal lords of that area. So we wouldn't know if the perpetrator of that crime was somebody rich. We'll just have to go by, and it's an unfortunate incident. I hope there's no repetition.
So, how much hierarchal and feudalistic is a court procedure in our country in terms of advocacy?
Are you trying to get me in trouble? See, these are old institutions with roots in Imperial England, right? Imperial British government. So yes, there are some hierarchical models, and in fact, if you look at it in ways which may be debated though, but that hierarchy has helped us bring some order, even though the jury is out to still debate whether it could have been achieved in a different way or not. I am a firm believer that you necessarily do not need blind submission to reverence and hierarchy to get things done. There has to be more efficient ways. It's just that you have to put intelligent people in a room and allow them the kind of brainstorming that it needs. That's it. But unfortunately that hasn't happened, and the courts are how they function, and I'm happy that in spite of all these complexities, these courts have still been able to do justice in majority of the cases. If you actually look at the higher judicial, I think till date, in spite of all the problems and all the complaints and all the apprehensions that have surfaced, people still run to court. So in spite of all the apprehensions, as long as people are running to court, there is hope. If the society is in a certain way, you cannot expect that your judges and lawyers will be completely different from that. But yes, still there are examples of people like B.T. Venkatesh, and one name, in fact, I was just talking to you before this interview started about K.G. Kannabiran, Sudha Bharadwaj. These people, in fact, I'm forgetting her entire name, Asma Jahangir. So she was a feisty lawyer in Pakistan who went up against the same problems, same complexities in the court structure, and they have been able to bring in change in their own little ways. I think we shouldn't lose hope. There are problems, I won't deny that, but we've been able to overcome that, and I think that's the best part of our democratic structure.
We will try to come up with another discussion on the new Labour Code Bill, which is due in the Parliament. But to end today's discussion, it won't end until we have a few words on the recent hawker movement which is taking place in the Vidhannagar Municipal Corporation area, where Saptarshi had actually fought a case in favor of some hawkers who were members of the People's Brigade Hawkers Unit. So, what was the experience?
I think it's a good experience whenever you get a chance to fight for the people who actually do not have anyone to fight for them. And their eyes, they may not be able to give you the kind of commercial fees that you look at as a commercial lawyer, but the gratitude in their eyes is the biggest fees of all. I personally am a believer that we have a strong case on that, because the government of West Bengal hasn't been able to, even though this is matter which is sub judice, so I will not go into the technicalities of it much, but yes, the government of West Bengal, in my opinion, hasn't been able to fulfill the mandate of the law, which is the Street Vendors Act. And unless when there is a law, the government has to act completely in accordance with that law or not act at all.